Good afternoon and welcome to today's edition of WARF Essential Topics. My name is Laura Heisler and I am Director of Programming for the Wisconsin Alumni Research Foundation. And it is our pleasure to bring you this series from time to time to discuss issues and topics related to commercializing technologies at UW-Madison. Today's session is part of a week-long series of focused topics through UW-Madison Startup Week. It began on Wednesday and continues through next Wednesday. And to find out about all the events taking place as part of Startup UW-Madison Week, I encourage you to go to innovate.wisc.edu, and there are events from a number of campus partners being staged throughout this week. WARF is hosting an event each day, and I'll just briefly mention the remaining events in our series for the UW-Madison Startup Week. We'll take a break over the weekend and we come back on Monday with a focus on what you need to know as a campus researcher about outside agreements, third-party agreements, consulting agreements, issues related to conflicts of interest, and other activities that you may wish to engage in while maintaining your status on campus. And we're doing that in partnership with WARF leaders, as well as leaders from UW-Madison's VCRGE office, legal office, and more. On Tuesday, we'll be putting together a special spotlight on models for how universities are effectively engaging women, people of color, non-traditional entrepreneurs who may have some additional considerations in moving their ideas forward through startups in particular. You might like to join us for that on Tuesday, November 17th. And then finally, WARF's contributions to Startup Week ends with a bang with Innovation Day, our annual event this year at 2 p.m. on November 18th. If you'd like to join any of these sessions, you can find out more about them and sign up to get a link at info@warf.org, or go to warf.org and go to the programming tab and you'll find a good link there. With that, I'd like to just say a few words about how today's session is going to go so that you know how to proceed. We'll be hearing from my WARF colleague, Beth Werner, Director of Life Sciences Intellectual Property at WARF. You can ask questions of Beth at any time during this session using the Q&A tab at the bottom of your screen. Just go ahead and click on that tab, ask your question. Depending on how the conversation goes, we may be able to handle your question in real time. Otherwise, towards the end of the hour, there'll be an opportunity for us to field your questions. So bring them forward during the Q&A whenever they occur to you. And with that, I would like to go ahead and turn things over to my colleague, Beth Werner, to say more about today's topic. Beth, it's all yours.
All right, thank you, Laura. Share my screen here. I'll get that in presentation mode. All right. So again, Laura, thanks for the introduction. My name is Beth Werner. I'm the Director of Life Science Intellectual Property at WARF. And my topic today is, what do you do when you realize you've got this cool scientific finding or idea? You think, maybe I could get a patent. Who do I talk to? Now what do I do? And my topic today is really going to be to give you sort of some basics around patenting and what that process looks like, and then spend more time working on kind of how WARF works and how you connect to WARF. And ultimately, we're going to end the session today by talking to a UW faculty member who sent in her first disclosure this last year. So she's going to give you real life experience on submitting the disclosure and the process, and we'll just have a little chat session with her at the end. So for those of you who don't know, the Wisconsin Alumni Research Foundation, WARF, acts as the technology transfer organization for University of Wisconsin-Madison and for the Morgridge Institute of Research. And our mission at WARF is to support scientific research at those institutions. And how we do that is by fostering this, we call it the cycle of innovation. And it's over here on the right side of my screen, where the university and the Morgridge Institute will pull in research funding. And that funding leads to cool science happening on campus. And a lot of that science actually will translate into marketable products. And so we at WARF are looking to talk to researchers on campus to identify aspects of their science that could be commercializable. And if there is intellectual property protection to be had, we'll secure that intellectual property protection. We also then will license access to the intellectual property to companies who then make the products and return licensing fees and royalty rates to WARF. That amount of money goes into an annual gift to the university that WARF puts out every year. And I believe this year, the annual gift to the university was around $88 million. So That is the cycle of innovation. And WARF was the first academic tech transfer office in the United States. We are one of the most successful tech transfer offices. And that all comes down to the amazing science that goes on this campus. And again, our ability to translate that into marketable products. So here's just some stats. Since 1925, we've obtained over 2,300 patents around technologies arising off of research at UW-Madison. And we've completed over 1,600 licensing agreements. So when I talk about intellectual property, I want to give you just sort of some basic ideas of the different buckets of intellectual property available around technologies. The bulk of what WARF does is securing patents on patentable inventions. And we'll get into some of the details of patents and what patents are and what they cover. But generally, you can think of patents as covering inventions, and inventions can be anything from new materials created, new methods of making, using, purifying some substance, improvements on methods or improvements on materials, compositions, chemicals, devices. So the definition of what is potentially patentable is pretty broad. The opposite of a patent is a trade secret. And it is the opposite of a patent because a patent, the deal with the patent situation, the patent process is that you are going to teach everybody your invention. And in exchange, you get this right to exclude others from making, using, selling your invention. Trade secret's the opposite of that. The value to a trade secret is keeping the details of your technology secret. It's anything in your business that could have value that is not something that's easily discernible from a competitor could be a trade secret. And one of the most famous trade secrets we always talk about is the Coca-Cola formulation. So Coca-Cola never patented the formulation of original Coke. They keep it in a vault in their Atlanta offices. And there are very few people in the Coca-Cola organization who know what that secret formula is, because again, the value to that trade secret is keeping it secret. So you don't want everybody in your organization knowing in case it might leak out. The other two types of intellectual property that WARF does work in is copyright. And copyright is intellectual property that covers a creative work put in a tangible format. And in the context of copyrights, a lot of what we're doing right now is looking at computer code as copyrightable. So computer code is copyrightable. When you code something, that code itself can be a registered copyright with the US Copyright Office. But code is not the only thing that we can copyright. We can copyright images, graphs, educational videos. There's a lot of copyrightable technology available and out there. And that is something that we will work on. The other type of intellectual property I'm just going to mention is trademarks. Now, trademarks are descriptive terms, slogans, logos, could be a color combination that build a brand around a product or a service. And the key to getting intellectual property protection around trademarks is that there's a requirement that the trademark is used in commerce. Now, WARF, we're a technology transfer organization. We don't actually make and sell products. And as such, we don't do a lot in the way of trademark and trademark registration. The few trademarks we do have are around technologies that were developed on campus for which we actually obtained patent protection. So I manage the cranberry portfolio. The university has a history of developing novel cranberry varieties, which ultimately are licensed to cranberry growers in the state. Wisconsin, you may or may not know, is the leading cranberry producing state in the United States. And we can get patents on the cranberry varieties that are being developed on campus. And on top of that, the breeders of these varieties are coming up with the catchy trade names associated with those varieties. And so we can register trademarks to protect those trade names. And you would do that because intellectual property has a set lifetime and a patent has a set lifetime. And again, we'll get into the details of patents a little bit later. Trademarks, the interesting part of trademarks in intellectual property law is as long as you continue to use the mark in commerce and continue to pay a fee to the Patent and Trademark Office, that trademark can go on forever. So your patented invention, that patent may expire, but the trademark protection around your product may continue as long as you continue to pay that fee and use it in commerce. Another trademark we have is around an educational product. So we had a researcher years ago who developed a fast-growing brassica plant line, and he termed those Wisconsin fast plants. Those are licensed, and we did have a patent on the kit that would be provided to schools to teach students around plant biology and physiology. The patent expired some time ago, but we do still have trademark protection around the term Wisconsin Past Plan. So that's just to give you some idea of intellectual property and sort of the scope and scale of intellectual property. And if you are thinking about starting a company up or thinking about technology and product development, think of it not just as one form of intellectual property protecting your technology, think of it as a portfolio of intellectual property that would be protecting your technology. All companies have huge portfolios of intellectual property protecting their business. So as I mentioned earlier, the bulk of what I do at Wharf is trying to secure patents on patentable inventions. And so I think I'd mentioned a little bit earlier that a patent is the right to exclude others from making, using, selling, or importing your invention. Now, one thing I like to highlight here is that a patent does not give you the right to practice your invention, and that tends to surprise people, where they secure their patent and they think, okay, well, now I can start selling my product that's got this patent because it's new enough that it got through the patent office, so it's mine and I'm going to start selling it. Well, you need to look at your product and you need to consider whether other people's patented technologies could be in your product. And the example I like to give is, let's say you created a device that is able to measure tumor volume. And that device requires a really special laser in order to be able to give accurate enough measurements. And it turns out some other entity has a patent around that special laser. Now you could get a patent on your device, but until you secure the rights to their patented laser to be able to sell it in your device, that would block you from potentially selling your device. So just keep that in mind again as you're thinking about entrepreneurship and startup companies and your products, that just because you've got a patent doesn't mean you're free and clear to go ahead and market and sell your technology. I'd also mentioned earlier, the patent system was set up as a quid pro quo with the government. So the deal is you get a measure of exclusivity for a set period of time. And in this case, with a patent, the lifetime is 20 years from the filing date of the patent application. Once that 20 years is up, it's out there and anyone is free and clear to use your patented technology because the patent expired. And that really is the beauty of the patent system. That's why it was created. It was created to incentivize and motivate innovators to share their innovations with the world, not to keep them secret. That's why I like to say that patents and trade secrets are kind of on opposite ends of the spectrum, that we don't want innovators keeping everything secret, because if you have innovators sharing their innovation, other innovators can innovate on top of that innovation, and it just keeps building and building and building. So it can take a long time to get a patent through the patent office. On average, it usually takes me about 2 to 5 years to get something through the patent office, something to issue. I think the longest it's taken to get a patent issued through the patent office was 9 years. That was a really painful patent to get through the patent office, and it was really costly. And that's sort of the last thing I wanted to bring up about a patent on the slide, is that the costs on average run Wharf about $30,000 to get an issued US patent. And that is just a patent in the US. So that's the other thing with patent law, is all countries have their own patent offices, and there are treaties, international treaties, that help harmonize patent systems to a point. But if you want patent protection in France, you're going to have to get a patent in France. If you want patent protection in China, you're going to have to get a patent in China. And if it costs $30,000 in the US to secure an issued US patent, you can imagine, as you keep picking additional countries around the world, those costs tend to escalate really quickly. The bulk of the fees that we're paying in the US are attorney's fees. And if you were an inventor and you wanted to file your own US patent, you by law can do that, so you would not be paying the attorney's fees. I will say it is a really complex, complicated process. And so the patent office encourages you, and I would encourage you to at least sit down and talk to a patent attorney before you go down that path. So the requirements for patenting, these are sort of the 4 basic requirements. If you're going to have an invention, and as I mentioned earlier, an invention can be a method or a material, a composition, a device. What it cannot be is it cannot be a product of nature, it cannot be an abstract idea, and it cannot be a natural phenomenon. And this eligibility question has changed a lot over the last 7 to 10 years as court cases have gone all the way up to the Supreme Court, and the Supreme Court justices have started to provide some granularity and change what was commonly believed to be patent eligible subject matter, which is no longer patent eligible subject matter. And I would just point out that the product of nature one is the one in the life science space I deal with a lot. And basically, prior to the Supreme Court case, which was really focused on isolated genetic material. You could get a patent on an isolated gene. You could get a patent on an isolated small molecule natural product. You could get a patent on an isolated protein. Now, based on the Supreme Court case in the US, I can't get a patent on an isolated natural product. I could still get a patent potentially on a method of using that product, but not the product itself. And what's interesting is, again, as I mentioned just a little bit ago, each country has its own patent system. This product of nature restriction on eligibility is specific to the US. So while I may not be able to get a patent on a new novel natural product antibiotic that somebody on this campus isolated and purified and characterized in the US, I could get a patent on that compound in Europe, Japan, in China. So even though we sort of globally have harmonized our patent system to a point, there still are some really interesting exceptions to that. Perhaps the easiest requirement for patenting is around novelty. And novelty is a yes or no question. And I will tell you, I'm a scientist by training. I have a PhD in biochemistry. I am not a lawyer. And I, as a scientist, when I got into law, kind of thought, well, law is going to be pretty simple. I mean, it's legal or it's not. It's yes or it's no. Well, it turns out that a lot of things in law are more gray area than I anticipated. And the last two requirements are going to be in those gray areas. But novelty is simply if the patent office finds a single publicly available reference that discloses your entire invention, your invention is not new. And there is no way to argue that with the patent office. Now, the patent office will mischaracterize references once in a while, and you certainly can point that out to the patent examiner. But if they did characterize that reference correctly and it is your invention and it was out there before you filed, then you do not have a novel invention and it is not going to be patented. The two more difficult requirements to meet and to argue with the patent office, and this is where we spend most of our time when we're trying to get a patent through the patent office, is around obviousness and enablement. So the rules are your invention cannot be obvious over what's been done before. And when I tell people that, they go, well, what does that mean? And I tell them, I wish I knew in many instances, what does that mean? So for the patent office, if you create a simple combination, let's say you take a known molecule that is clinically approved to treat pain and another known molecule that's clinically approved to treat inflammation, and you put them together and you say, okay, this works exactly, it does treat pain and it does knock down inflammation. It's what's expected. The patent office will look at that simple combination, that simple addition of A plus B, which gives you the expected additive result C. And they'll say, well, you knew that, everybody knew that. So it's A plus B, it equals C, that's obvious. If, however, you take A and you add B to it, something else, and you see some sort of synergistic effect or some exponential result, or you expected it to be C and it turns out, no, it was W, right? Something completely unexpected and completely new and completely, you never would have guessed that that was going to happen when you put those two things together. You then have a good case to make to the patent office that something isn't obvious because it didn't result in the expected product. The other thing I tell research when we're talking about obviousness is every time you fail, I feel bad for you as a scientist and a former researcher because I know how hard research is, and I know that's my graduate student thesis tagline could have been lots of ways to fail in this. So I understand how hard it is from a scientific standpoint to fail in research. From a patent standpoint, failures are wonderful for me because when the patent office comes back and tells me that the invention we filed on is obvious, and I can point out to the patent examiner the different ways we tried and failed, that's a great argument against obviousness because again, no one is going to pick the route of failure. You fail, you learn, you tweak things, and that ultimate invention that arose out of the tweaking is what ultimately can overcome the obviousness rejections. The other one I have to deal with a lot in life sciences is enablement. And enablement is basically you have to provide enough detail to teach others how to make or use the entire invention. And that is because once the patent expires, the world gets access to that technology. So there has to be enough detail to allow the world to have access to that technology. The difficulty arises because the patent office considers chemistry and biology to be unpredictable arts. And because they are unpredictable arts, the burden falls on us, the applicant for the patent application, to provide enough data to actually support the breadth of an entire patent claim. And the example I use a lot is, let's say you create a novel cancer therapeutic and you test it on a couple of breast cancer cell lines and it looks fantastic. And we file a patent around the compound and around a method of using the compound to treat cancer. But all we've got is the compound against breast cancer cell lines. Well, the patent office is going to come back and they're going to say, well, okay, that's an interesting compound, but you've only shown it works against breast cancer. You haven't shown it works against prostate cancer or pancreatic cancer or melanoma. So you don't get a claim to any cancer. You get a claim of a method of using it to treat breast cancer. So from my perspective, then I'm going to need the researcher to provide additional pieces of data showing that it is effective against other forms of cancer if I have any chance to get a claim around a method, broadly around a method of using it to treat cancer. So again, the burden falls on us, the applicant, to prove to the patent office that in these unpredictable arts, we have enough data to show our invention is going to work at the breadth we're trying to claim it. And the government has scientists to train or examine patent applications to make sure they meet all of these requirements. When you submit a patent application, it's assigned to an examiner based on their scientific expertise. And it really is a hodgepodge, I'd say. I mean, sometimes we get examiners who are just spot on in their scientific expertise in our invention and they get it right away. And some of them, we have to spend a lot of time educating them on the science and the technology before we can even start getting into the details of patent law and these requirements. So one thing I really wanted to focus this talk on in the patent side is the most challenging aspect of working in an academic setting in patent law, and that is around public disclosure and prior art. So in the previous slide, we talked about novelty and non-obviousness. Those two requirements are judged based on prior art, and prior art are references that are publicly out there, and it can be patents, and it can be papers, and it can be poster presentations, and it can be blog entries, and it can be pretty much anything that's out there available to the public. Now, as an academic researcher, what we all know is you guys talk about your research all the time. You're constantly sharing your research, be it at meetings and posters or in departmental seminar series or publishing loads and loads of papers. So from my perspective, your own publications can be some of the most damaging things I have to deal with when I'm arguing with the patent office over novelty and obviousness. And this little timeline just shows some kind of where public disclosures and patent applications can happen and where we should really be careful about the timing aspect. So on one side, we've got the patent filing. And basically, if any other party other than you, the inventor, has publicly disclosed anything around that invention before that patent filing, that is going to be prior art that's going to be used against us by the patent office to try to either prove that our invention is not novel or to prove that our invention is obvious. So anything before that patent application filing date. The one caveat to that is in the US, you get a year from publicly disclosing your invention to file a patent application in the US. So you actually, and I've had this happen on plenty of occasions where you're getting ready to go to a meeting or you've submitted an abstract to a meeting, and I get a quick call saying, hey, I should have talked to you guys earlier. Now I'm presenting this poster at this meeting. Is there an invention here? What should I do? Talk to us before that. Even if it's the day before, just feel free to reach out to Wharf and to talk to us about what you're going to publicly disclose. Wharf has the resources and the expertise that if we have to move quickly on something, we can move quickly on something. In some instances, we're only worried about the US market. So you publicly disclosing it at that meeting gives us the avenue to still file a patent application on it in that intervening year. So I wouldn't be overly worried. But again, I would highly recommend you not making that call. Just contact us and we're happy to talk to you about your research and when the public disclosures are happening and try to come up with a strategy around that. So I wanted to give you just sort of a list of some public disclosures, because I know that is one thing I get a lot of questions around as well. Is this really a public disclosure? So here are some. I think one thing I would kind of highlight our sales reps discussions. So when I was in graduate school, and maybe nowadays since we're virtual, it's not as much of a problem, but when I was in graduate school, we would have sales rep coming around asking us about our research, trying to sell us product. And depending on the details you're giving to them, they are outside entities, and those discussions could be considered a public disclosure. I think departmental seminars are another one because that happens a lot. And people kind of go, well, nobody from the public is coming into our departmental seminars, so how would that be a public disclosure? The criteria for what makes it a public disclosure is if it's advertised and if someone from the public could attend, odds are that's going to be considered a public disclosure. If, on the other hand, you've got a lab meeting, and if we were not virtual and we were having in-person lab meetings, and you had somebody from the public walk into your lab meeting, you'd look at them and go, you don't belong here. That's not where, this isn't open to the public. So a lab meeting would be considered not a public disclosure. And that gets me to the next slide. Is submitting grants to most funding agencies not considered a public disclosure? Submitting a manuscript to a journal should be fine. Submitting an abstract for a meeting should be fine. Discussions with scientific collaborators. So again, if in doubt, please contact us. Which gets me into, how do you contact us? What is WARF's IP management process? And I will say there is no wrong way to contact us. Go to our website, it's warf.org. I will make a pitch. We just got a new website. It's great. It's easy to get around. One of the first links on the front page is if you're an inventor and you want to submit an innovation disclosure to us, it's a web-based form now, super simple. Otherwise, all of our contact information is also online. Feel free to reach out, email, phone. We can do Zoom meetings. Happy to talk to you guys about science. I'm a scientist, love to talk about science. So reach out and I'd be happy to talk to you about science. So the first step in the formal form is to have you fill out an innovation submission form. And basically these are the questions we're going to ask. Who are the innovators here? What is the innovation? And I will just highlight again, we're changing the wording from invention, which has traditionally been what we've used in invention disclosure report form, to an innovation, because we're interested in not just patentable inventions. We're interested in any type of innovation you're making in your lab and your research. We're going to ask you what makes it superior. We're going to ask you about funding around that. We're going to ask you if you've got any plans around public disclosures. The next step in our process is we at WARF have an internal committee that meets once a month to review all the innovations disclosed to us over that month. And the meeting happens on the third Thursday of the month. We determine whether to accept or reject the invention or the innovation or the copyrighted work. Our accept rate runs about 50%. We typically see about 25 to 40 disclosures every month. So you can roughly estimate that we get maybe around 350 disclosures a year, which really is pretty phenomenal, as I say. Our criteria for accepting, we're talking and discussing amongst ourselves to try to determine the breadth of the intellectual property protection we can get. How strong is it? How broad is it? How much of market exclusivity are we going to have? Because the more, the better, the more valuable it's going to be. The strength of the IP protection, are we going to know if companies are using the method, if it's just a method, or using the invention, if it's a methodology they're going to use internally? We may never know that they're using it internally, in which case we've got a patent that we never could enforce. That's going to limit the value of that patent. The likelihood of finding a commercial partner, there are technology sectors where in licensing early stage technologies from academia is just not the focus of their business strategy. And so it becomes more difficult to find commercial partners in those areas. And then we're going to look at the licensing return. It's not a make or break decision for us, but keeping in mind our mission is to return money to support research to campus. We have a responsibility to make sure that we're not spending $30,000 on a patent for a technology that, if it's super successful, is only going to net $10,000 back to the university. So you will hear from us after our disclosure meeting about what the decision is, and the university will start going through what we call the equity review process. And that is something that's run through the Vice Chancellor of Research and Graduate Education's office. They will look at funding that was in the lab and all other legal agreements, could be material transfer agreements or sponsored research agreements, and they'll send out an official letter to let you, the inventor, and to let us at WARF know what funding has gone into that, or if there are other agreements and other potential obligations around assigning your rights to intellectual property, or around our obligations to maybe give an option to a sponsor. Those are things that the university will determine and let us know. We ask these things early on in the process because we want to make our decisions with as much information as we can, but the university gets the final say on that. So if you do go through the process, I really recommend you take a look at that letter and make sure that the funding and the legal agreements associated with the invention they're accurate and they haven't missed anything. They do a great job, and it is a really hard job, and I do not envy them that job. Ultimately, we're going to sit down with a patent attorney. So WARF will hire an outside patent attorney or patent agent to sit down with the investigators and to work out the details of the invention and draft up the patent application. We don't do our own in-house patent drafting. There is no cost to any investigator on campus or at the Mortgage Institute for working with WARF. So we foot all of the costs. And if we do have success licensing your technologies, we share the licensing revenue with you, the inventors. So the inventors get 20% of the licensing revenue that we bring in to split evenly amongst themselves. 15% of the licensing revenue goes to the inventors' departments, and then the remaining amount of licensing revenue goes into the WARF fund that ultimately funds the annual gift to the university. So I won't get into too many details because I think we're running low on time around licensing, but I just wanted to mention licensing. And I know because this is startup week, one thing we are looking at is licensing technologies to startups. And if you do have an invention arising on campus and you disclose it to WARF, if you're interested in starting up a company around that, by all means, we want to know about that early as well, because we are very motivated to help researchers start up companies on campus. That being said, we're not just going to freely turn over technologies to startups. We're actually going to make sure you have a business plan, to make sure that you have looked at the market, to make sure you have a plan for how you're going to secure funding in order to develop this in a developmental timeline that makes sense. So these are questions that we would ask any entity that's going to license from us. And so these are just some of the lists of the larger established companies that we've worked with. We can basically craft licenses. We have a lot of flexibility to craft licenses in ways that make sense. Our goal is to get technology out to the market. Our goal is to be good, find good partners for the technology. So we have a lot of creative licensing managers here at WARF who can come up with creative solutions to create business partnerships that can work for WARF and for the commercial entity. So my take homes, they're all pretty much around talk to us, please, talk to us. Love to hear about science. Publicly disclosing your invention before you file the patent application can really limit the patentability of your invention. So please talk to us before you're going to disclose. And even if you've disclosed, hey, again, in the US, we still have a chance to file a patent if we decide to accept the technology. So reach out to us anyway. And we'd love to talk to you. So feel free. I can't encourage you enough that you can access WARF through any way that's convenient to you. And I think that is the end of my talk. So I'm just glancing at the Q&A quickly, and nothing is popping up there. The next part of the talk is I'm going to have a UW faculty member, Jenny Gumpert, who's going to join me for we're going to call it a fireside chat. As I mentioned before, she sent in her first disclosure this year. And she is one of 6 finalists for the WARF Innovation Awards, which that is a great return. 1 disclosure, 1 award finalist. If it was me, Jenny, I might actually retire at this point and just take my 1000% and say, I'm good. But you'll be able to meet other finalists and learn about their technologies through additional upcoming web series. We're going to ultimately have an event in December where we're going to show videos and talk about these really cool technologies. The Innovation Awards it's something we started at WARF a number of years ago. And I'd mentioned in my talk that we get about 350 disclosures on average a year. In WARF, we sit down every month and we identify the ones that really wow us, the ones that are just have the potential to make a huge impact scientifically in these different technology areas. And that is not an easy thing to do. I will tell you guys, it is really hard to look through these amazing technologies and pick out a few that sort of rise to the top. At the end of the year, we review our list and cull down our list to a manageable 6 technologies. And then we have an outside panel of external judges who judge the technologies and ultimately determine the winners of the Innovation Awards. So stay tuned for more information about the Innovation Awards. I believe we've got the video for Jenny's technology, so I'm gonna go ahead and let them play that for you.
I'm Beth Werner, Director of Life Science Intellectual Property at WARF.
And I'm Andy Datina, Director of Licensing. We're pleased to recognize the cancer immunotherapy work of Drs. Jenny Gumpers and Donna Bayou for this year's WARF Innovation Awards.
By combining two kinds of cells found in the body, Jenny and Donna's work could open up a potentially transformative new approach to immune oncology, one that is faster and more specific than current methods.
Congratulations to your great team, and we're very excited to follow the progress in the days to come.
Hi, my name is Jenny Gumpertz. I'm a professor in the Department of Medical Microbiology and Immunology at UW-Madison. We all know that cancer is a tremendous problem in our society, and in recent years, there's been a lot of excitement about using the immune system to fight cancer. So the current ways that we do that have some problems associated with them, and those have to do with not always activating immune cells specifically enough, or in some cases, it's possible to generate immune cells that we actually grow in the lab and genetically modify and put back into patients to fight their cancers. And that's really very exciting, but the problem is that it takes a long time and a lot of cells, and cancer patients just don't have a lot of time. Our invention involves taking a population of cells that we all have and preparing them ahead of time in the lab. Then we can conjugate those cells. We can join them to another kind of cell that's very specific and specifically activates T cells to kill tumors. These conjugates, these pairs of cells, can be prepared ahead of time and stored so that when patients come in ready for immunotherapy, they can be given these cells without delay. So our current stage is that we're testing our human cells in special animal models where we can create a human cancer in the mice and test our human cells in those models. The next stage will be to move on to doing pilot clinical trials, and that will likely take a few years.
During my career, I worked in the fields of immunology and cell biology, and my research focused mainly on basic research problems. I'm really excited that this research has such a high potential to be translated into a clinical trial in the near future.
All right, that was great. And I will say, I've been at WARF now for over 15 years, and I get to hear about a lot of cool science. And this was one where Jenny sent in the invention disclosure report form, and I went down to her office and talked to her, and I went out after I left her office, and I'm like, wow, that's wow. So I was really excited to see it make its way through the process and be one of the finalists for this year's Innovation Awards. And Jenny, thank you. Thank you for taking the time and joining me.
Well, thanks very much for inviting me. And I just want to say, I actually think that that video speaks volumes about WARF's abilities and professional acumen, because, you know, I would have to say it's pretty obvious I didn't major in drama or acting. And, you know, as scientists, we kind of don't. But, you know, I think, WARF has succeeded in making something that may have actually worked in spite of all that.
Always a shout out to our communications team. They really are top notch. I mean, I'm not shocked anymore because they really are good, because I'm not either scientist. I mean,
they are good. I'd have to say they're good.
Really good. Well, for sure. So I just had a couple of questions, and I know we had talked a little bit beforehand, and we can kind of just have this be free flowing. And if questions come on through the Q&A and people have specific questions, we're happy to answer those too. So what made you decide to disclose to WARF? I mean, this was your first disclosure.
Yeah, I mean, I had been thinking for years and kind of listening to other people talk about their experiences with WARF and feeling like, ooh, I wish our work, would like, I wish I could, feel like I actually had an invention. And, I think some of what you talked about earlier today, even though I may not have had as good of an understanding, and you've really helped to develop my understanding about this, but kind of that realization that when we transition in science from sort of just studying a natural process and understanding these natural functions or kind of recreating this natural thing or something like that, to a situation where it's like, oh wait, if we take these elements and work with them in this way, we can generate this, basically this product. That's when it sort of transitions. And there was a particular time, in our research where I realized, oh, wait, we can put these things together in the lab and generate this a potential product this way. And it really was kind of like this little ding, like, oh, wow, this is something that I should talk to WARF about. And so that really and it was tremendously valuable to me that you came and talked with me personally, and you had a sort of vision for or a sense of the potential, because as a scientist, mostly we spend all our time kind of feeling like you have to be at least 120% sure before you can publish or do this or do that. And somehow, it's really hard to, kind of say, no, actually what we're talking about here is not, that we've already made it work, but that it has the potential to work in the way that we're seeing signs that this really has potential.
Yeah, and I think that's a great example. And I get questions just like the one that popped up in the Q&A right now, is when is it too early to bring us an idea to WARF, or when is the best time to talk to WARF? And again, I can't stress it enough. There's no bad time to talk to us. I mean, there truly isn't. And you can never talk to us too early, but you certainly can talk to us too late. If that public disclosures happened more than a year ago and we find a really neat technology, if that has happened, there's not much we can do from a patent standpoint, which is unfortunate. But I think I should stress as well, and just as you said, Jenny, you don't have to have enough to have a manuscript ready for a peer-reviewed journal. I mean, that is, I like to tell researchers, that's kind of, I would say, if you needed a break point of when should I talk to WARF, that would be it. Don't wait much longer than that. I mean, you can submit the manuscript and we're still okay because we've got months for it to get through the research. But if you've got that amount of data, you're good. The patent process, it's not peer-reviewed journals. It's not you. If you've got, just as Jenny had, you've got enough data to say, yeah, this looks like it's working. This is pretty exciting. Sure, there's a lot more work that's got to be done, and an additional science has got to be done to validate it. We'll make the call if maybe we don't file right away. And Jenny, how long did it take us to file? I mean, we met. And
yeah, I mean, actually, I think that the main part of the delay was, aside from sort of COVID related restrictions or whatever, I think that we in sort of learning about how the process was likely to move forward, and the filing of a provisional patent, giving a 1-year time frame before the final patent, and kind of understanding a little bit more about the potential sort of novelty, or I think we actually made the decision to kind of not jump in right away quite as quickly as we could have, and so we waited at least after talking with the lawyers, which was also very, very helpful. We waited at least another 6 months, if not actually maybe a little bit longer than that, maybe more like 9 months, because we wanted to really kind of be able to address as many questions as we could, just to kind of strengthen the provisional patent, so that in that 1 year, once the clock starts ticking, that we could get as close as possible to getting the strongest actual patent. So yeah, I guess we did take a little longer, but from my perspective, it was very helpful to know that we could have moved forward very quickly. And we also could take the time to do the scientific work that we kind of felt was important.
Yeah, and I'll just echo that. I mean, we made the conscientious decision to kind of slow walk this to filing, and we did it for a strategic reason. So in the therapeutic space, this technology has the potential to be a very important therapeutic. In the therapeutic space, you're looking to maximize your patent life available. And therapeutics take such a long time to get through preclinical studies, to get through clinical trials. So from a strategic standpoint, if we file on therapeutic inventions way early, we're going to end up burning up patent life during the development phase. So from my perspective, from a therapeutic, as long as there's no public disclosure, as long as there's no paper ready to publish or presentation that's going to happen, sometimes we'll hold off filing on a therapeutic invention until that public disclosure is going to happen. It was kind of ironic in a way because the public disclosure for your technology is the video that we just showed. So it's Wharf doing the public disclosing of it. But the trade-off, and I don't want to dominate the conversation too much, the trade-off to holding and waiting is we don't want someone else to get to the patent office before us. So we don't want to wait too long. So there is a chance that you would wait too long and then someone else could scoop you, because that happens with the patent system these days. Is we are now a first inventor to file system in the US. So the first inventor to get that patent on file, they're the one that's going to get the patent around that invention. So you don't want to wait too long. There's a quick question, is the presentation being recorded? And the answer to that is yes, it is being recorded. So the disclosure process itself, I think we'll do one more question or one more discussion point here. And then if there are some more questions, that would be great. But what was it? How was it? I mean, you can tell me good and bad. So we won't just say, oh, that Jenny, we're not working with her anymore. She had nothing but bad things to say. I love to hear if there are things that we could improve on, I'd love to hear that too. But just again, as a researcher who may be thinking of going through the process, can you just kind of give me your opinion of it, or what worked, what didn't, what surprised you?
So disclosure meaning filing of the innovation disclosure report, or?
We could go both. We can go the submitting of that, the process, the notification of it, the meeting with the attorney, just the whole process.
Yeah, I mean, so I think that, the form for me felt, pretty clear, pretty straightforward. I do have a little bit of a phobia of anything that looks like a form. So that was helpful that it actually, it worked well. But, my experience has really been great. Like, I would say what has really worked well for me has been, having a chance to talk with you and Andy D10 and others at Wharf in kind of a collaborative way where, I kind of feel like I've been able to learn, some of the kind of what are the key issue steps, kind of milestones or deadlines. I think much like the way that, outside, if you're not a scientist, it seems like science is this very sort of clear-cut process that you just kind of know what you need to do. Oh, okay, we learned this and then we figured out that, like, somehow you've like science just is very kind of straightforward. And in real life, you're presented with all these different options in science and you don't really know what way to go, and you kind of have to feel your way forward. So, being not really well-versed in business or sort of the, more in industry or commercialization sides of things, it always kind of seemed like it must just be, there were roadmaps. People knew how to make a business plan and they knew how to do this and do that. And I think that one of the things that has really been very helpful is kind of gaining a perspective from Wharf that, and the people that I've interacted with, that there is this kind of, there are choices and it's not just clear ahead of time and we have to figure it out together, and sort of learning, kind of being able to say, okay, this, from this perspective, we might want to do it this way, from that perspective, we might want to do it that way, and having, sort of input and help. Like, that's basically the main thing, is that if somebody would have said, are you going to be able to, are you going to generate an immunotherapy? I would be like, well, I might generate the starting point, but there's no way I'm going to actually do it because I couldn't possibly. And, the situation with WARF helping and coordinating other resources here at UW, like the Catapult program, I think, have, really kind of made me feel like, oh, okay, actually there are these knowledgeable people and support and resources to help me to take this, whatever steps are needed.
No, and I think it's a great point. And I'm glad you brought up the Catapult program and the Forward Bio Institute. And I think it is one of the things that WARF really values, being a member of this ecosystem. I mean, it's an ecosystem. And again, I've been here for 15 years. It's grown tremendously. The ecosystem around resources, around entrepreneurship, resources around technology development. And if you contact us, we're going to act as sort of that concierge to try to put you in touch with other people, and the other resources and other programs on campus will do the same. We try to keep in really close contact with them. And I think, again, for Startup Week, that's a pretty important piece of information, is we're all in it together. And I'm glad, Jenny, you brought up, I think that one of the earlier questions about when is it too early to talk to WARF? We're not going to direct your research. I mean, one, we shouldn't be doing that because we don't know. We don't have the crystal ball to say, hey, this is where you guys should be going. And two, you guys are the creative scientists. You know what's going on. But just as Jenny said, there may be lots of different paths you can take. And if we have these conversations and it becomes clear that this path both is interesting scientifically to you and will answer scientific questions that you're interested in, but it also is interesting to commercial entities and will help us in that technology development piece, then I think that's a great way to have a partnership. So I'd encourage you to talk to us early, I think, is really my final take home. Let's see, there is a question that popped up. So we've got a student in computer science, and they'd like to confirm that WARF would not be the best match for something like a tech startup, a website app. Oh, and they also want to give you a shout out, Jenny, that your work sounds amazing. So the computer science question, I think, is a really timely question, in that historically, WARF has struggled a little bit on the computer science space because web apps and some computer software programs just don't lend themselves well to patentability. That being said, we've had great success licensing out computer software, so I won't say that it can't be done. It certainly can be done. It is a big focus area at WARF right now. And WARF and the university we've launched the Varsity Venture Studio, which I believe was part of Startup Week as well. So if you as a computer science student are interested in learning more about how to spin out an app or spin out a computer program, I would actually encourage you to talk to WARF, because if we aren't the right partner for you, we likely can put you in touch with the right partner or resources that could help you. And so again, I'd encourage you to contact WARF. No downside to talking to us. I mean, just talking to us doesn't mean that we own everything that you do going forward. So don't think that that's the case. It's not the case. There's no downside to talk to us. Use us as a resource. Oh, and that was all that was in the question and answer. I know I'll throw it to you, Jenny. Was there anything else you wanted to? I think you did a great job. And like I said, I will just thank you again for being a great partner in this.
No, thank you. If people have specific questions that they think I can help answer, I'm happy to, communicate by email or whatever. So.
It's great. And I'm looking forward to seeing this technology really. I mean, like I said, this is one where I think if we can get this developed and we can find the right partner for it, this will be a game changer. So I'm super excited to see how it goes.
Well, thank you. It's really, that's one of the other things, I guess maybe my last thing to say is that in science, it practically never feels like you have anyone else in your corner. It's like, maybe, your lab or, maybe a few colleagues or collaborators, but it just feels like, you do deal with a lot of failure, a lot of long odds. And that has probably been one of the greatest things about this experience, is that it just has really felt like, wow, you know, I have a partner here that's, you know, really committed to helping to move this forward. And it really feels like, wow, I have, you know, someone in my corner now. And that's just really, it's incredibly helpful to have just that, even just the sort of the validation that somebody else thinks this is a good idea. So thank you.
Great. All right. Well, it doesn't look like any more questions are popping up in our Q&A. So Laura, I guess I'll turn it back over to you.
Great, thank you so much. Thank you both for a wonderful discussion. Thank you, Professor Gumpers and Beth, as always, really informative and engaging and entertaining as well. I wanted to just mention, if you are interested in catching any of the previous sessions that we've had this week, including the one that Beth referred to about Varsity Venture Studios, you can find all of those videos at either warf.org or at discovery.wisc.edu by searching videos. So those should all be available, as will this session. Will be the recording will be placed there, as well as the sessions next week. But I do want to remind you that on Monday at 6 p.m. we'll be talking about 4 p.m. we'll be talking about conflicts of interest and consulting agreements. On Tuesday, we'll be talking about how to make the entrepreneurship enterprise at UW-Madison more inclusive. And then, of course, on Wednesday, we conclude with Innovation Day at 2 o'clock. And you can sign up for any of those by going to warf.org. So thank you all so much, and be well and have a great weekend. And we hope to see you at some events next week. Thanks, everybody.